agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Michael Baranowski, a professor of political science at Northern Kentucky University. I'm joined today by my conservative counterpart, Cleveland area attorney and defender of freedom, Jay Carson.
Hey, good morning, Mike.
Hey, Jay, and a special thanks to Jay. At the last minute, Kristen had a colossal, catastrophic equipment failure, and with literally minutes to spare, I texted Jay and said, "Can you fill in at the last minute?" And he swooped in like some sort of a superhero. I don't know, an Avenger or certainly not Hawkeye. You're better than Hawkeye quality, but anyway, Iron Man, yeah, Captain America. I always said if you were an Avenger, you'd be Captain America. I'd be more of an Ant-Man, Spider-Man type. But anyway, you are here, and thank you so much, Jay. We really appreciate that. We also appreciate what a segue, our newest Patreon supporters, Scott and Mike. Thank you guys so much. And you all know the deal at this point. When you're a Patreon supporter, you get our second full-length bonus episode every week that comes out right after the show. So this week it's going to be a little bit later because we had to juggle some stuff around with Jay's schedule, but it will be out maybe in the mid to late afternoon on Saturday. You also get ad-free versions of all our shows, other stuff at different levels. You know what to do. Go to patreon.com/politicsguys to sign up, check it all out. And if you'd like that bonus show, but you can't afford to support the podcast right now, just send me an email, mike@politicsguys.com, and I will get you all set up. And, of course, we are also at Venmo at Politics Guys. Today, we are going to be talking about the Supreme Court's abortion ruling, the Texas voting law, more on Afghanistan with President Biden's speech on the U.S. final exit, Joe Manchin calling for a strategic pause on spending bills, Social Security and Medicare insolvency, the House Armed Services Committee proposing legislation that spends around $24 billion more than the Biden administration wanted, and okaying the idea of women registering for the draft. And finally, is Minority Leader Kevin McCarthy threatening tech firms? We'll get to all of that between the regular show and the bonus show. Before we do that, we need to take a quick break, and we will be right back to kick things off. All right, Jay, so are you ready to go?
I am. I am ready, Mike.
I am less ready.
I'm always ready. That's the good thing about me, as you pointed out.
That's true. You are.
I am always prepared, or if I'm not always prepared, I excel in just winging it.
I have to say, there's of all our hosts, there's no question that the quickest kind of off the mark is definitely Jay. I've known that for years, but. So you are probably more ready than I am because we were going to do the show with Kristen, and when it's a Kristen and Mike show, Kristen does the story intro. So this will have a little more of I always say to Kimberly, I feel like I teach my classes like I'm like a bad jazz player, like sort of an improv, but not necessarily a Sonny Rollins or Miles Davis. So, but we'll do our best here.
I am. On the other hand, I am the John Coltrane of podcasting. I think.
No question. And that's a good analogy because Coltrane would sometimes go off on these things and say, "Well, what exactly is going on?" But eventually,
where's he going?
Yeah,
I get it at the end.
All right, but we will muddle through certainly. And like I said, our top story this week is the Supreme Court abortion ruling, and we're a divided court, 5-4, with Chief Justice Roberts joining the minority, refusing to grant a stay on the Texas heartbeat. I think it's called the heartbeat bill, which is sort of a misnomer, some would say, because at that point there's not actually a heartbeat per se, but everyone gets the idea. And in any case, I think we all probably are vaguely aware of the basics of this, and that is after 6 weeks, bans abortions after a fetal heartbeat can be detected, and that's around 6 weeks or so. And there's no exception in this law for rape or incest, though there is a medical emergency exception. And the interesting thing about this law is the enforcement mechanism, because normally when abortion restrictions are passed, the state actually is the one that enforces them. But in this case, in a unique twist, Texas designed the law so that not the state, but private individuals bring suit under this law. They can sue abortion providers or anyone who assists a person in obtaining an abortion. And would get if successful, get a minimum of a $10,000 award, and I believe that's also plus costs. Although,
fees, yeah.
Although there is an exception, if you are a man who impregnates a woman through rape or incest, you cannot bring suit. And so the plaintiff,
that just makes sense.
Yeah, well, yeah, but you can find somebody who would do it anyway. But the plaintiffs are suing, actually, who's being sued here? If the state doesn't have the authority to enforce this law, then who exactly is responsible? Well, that's the tricky part of this law, right? So the plaintiffs are suing a Texas state judge, a guy named Austin Reeve Jackson, who, as a judge, would be in a position to actually process these potential abortion-related lawsuits. And in the decision, the court's 5 real conservatives, as opposed to Chief Justice Roberts, who I think a lot of people on the right feel is squishy, basically suggested that because of the novel nature of this claim, or of this statutory construction, I guess you could say, that they didn't want to jump in and rule on this, and kind of wanted to wait until lower courts could carefully analyze the facts and what's going on here. And the 4 in the minority basically said, well, 3 in the minority, the court's 3 liberals, said, you guys are nuts. This is a blatantly unconstitutional law. It prohibits essentially abortions after 6 weeks, when a long line of precedents say around fetal viability, which is 22, 24 weeks. And so you have your heads in the sand, as I believe Justice Sotomayor said. Then there was Justice Roberts, who joined with them in dissent, but basically just said, well, this is a novel issue, and so I would just want to keep things the way they are until we can kind of sort these out. And so I think that's more or less an accurate description of the opinions. Jay, what was your take on this? Did the majority get it right here?
Yeah. Well, I think something that's important to point out, there's been all this sort of apocalyptic rhetoric in that I've seen just social media and so forth, that this is the end of Roe versus Wade. This is the court is totally illegitimate. We need to pack the court, so forth. This is a procedural ruling, and I think you hit the nail on the head. This is a weird statute, and I'm not familiar. I can't think of any parallel with this, other than I'm thinking back to like ancient Roman law, right, Mike? When they didn't like somebody, they would put them on a prescription list, which Rome didn't actually have its own police force. So what happened was you put somebody on the list of prescribed people, and you could just kill them.
Yeah.
So it's sort of the emperor put you on the list. If there was somebody who was kind of had it in for you anyway, they could go out and kill you, and Rome would say, hey, thanks for taking care of that for us. So it's a little weird like that, where it turns over what ought to be a police function to private entities, and not even like regular an established sort of private entity, but anyone, just sort of anybody.
One of our listeners on Discord said it basically allows any citizen in Texas or anywhere else to be like their own private abortion Batman, just kind of going around.
Exactly.
That's just, it's kind of scary.
I like that phrase, though, abortion Batman.
I thought you'd like that, yeah.
So my sense is this is really novel. And I think there are a whole lot of problems. So, the obvious constitutional problem is banning abortion after 6 weeks. That's certainly not in keeping with current precedent. Could current precedent change? Of course, but that's gonna take place in a more ordered, briefed discussion, back and forth, and looking at precedents and so forth. So, but the other thing I think that the majority very much got right is who exactly is being sued and what is being sought to enjoin. One of the biggest principles of the judiciary is it only decides cases and controversies. It doesn't issue advisory opinions. So, you can have a law that says that it really, really looks like it's unconstitutional. And certainly based on current constitutional law, this one looks that way. But the Supreme Court's job isn't just to weigh in and give an opinion and say, man, this looks bad, we're not going to let it take effect. Their job is, when there's an actual case or controversy, to wade in and say this, decide that dispute between the parties in that controversy. And I think there's a really good question about who are the right parties here. I mean, for example, if you just enjoin a judge from hearing certain cases, even if they haven't been brought, again, that strikes me as being sort of wading into the advisory opinion piece. And that's, no matter what your feelings on abortion are, I think that's a bad place to go. When you start getting into a situation where courts can just say, hey, here's what we think the law is, it sort of wanders into here's what we think the law ought to be. And at that point, they're sort of surrendering the judicial function for the legislative function, which I think is a bad thing. So all that said, I think the majority gets it right on a procedural point, and I think one of the first lines, maybe the second line, is there looks to be big constitutional problems here. So it's not as if the majority is somehow saying, yeah, this looks like it's okay. I do think that there's the procedural issue, and also more important when you're dealing with something this big is to make sure you've got the procedural I's dotted and T's crossed, right? So that you're not saying, hey, here is, again, I think that goes to legitimacy of the court, that you don't want a court just wading into something, particularly where it's a big political issue, when there are good jurisprudential reasons to stay out of it. And there's also, I think, plenty of remedies that plaintiffs could have to block the law outside of the U.S. Supreme Court at this point.
It seems, and I think those are some important arguments, especially the court, the majority writing, well, what exactly are we enjoining here? We don't enjoin laws. We enjoin individuals from carrying out laws. And so we have nothing to enjoin here. And that, to me, was the strongest part of the majority's argument. It's kind of central to it. But then I thought about, and Jay, you'll be able to comment on this, that sort of the general standards for when you issue an emergency injunction. And the two big things that come out that are always the case are the probability of succeeding on the merits and also some sort of irreparable injury if this thing is allowed to go into an effect. And it seems to me here that this is where the plaintiffs make a pretty strong case that both of those things stand. Under current constitutional law, there is a high probability of them succeeding on the merits, and also given the fact this could prevent women from obtaining abortions, then there would be an irreparable injury if the law is allowed to go into effect. So it seems to me that that's a strong argument as well.
I think the likelihood of success on the merits is stronger. I would say almost overwhelming. And there's certainly a body of case law, and they recognize this injunctions that look, when you've got a like 100% likelihood of success on the merits, your need to show irreparable harm sort of decreases proportionally.
Yeah.
So I think that's a good argument. But to me, the bigger point is the who do you enjoin, the ripeness piece of it, and that to me is the issue. And I think look, if the way to solve this is if someone goes for an abortion, they can't get one, and the reason, well, this person's afraid of getting sued or actually is sued. And
that's the point. Is who do you sue then?
At that point, you've got somebody files the suit. You've got a ripe case, and there you go.
But that's the devilishly clever thing about this law, right? Because even in that case, and there have been reports that people are being turned away from Planned Parenthood offices in Texas and saying, well, there's not actually a lawsuit, but we want to avoid a lawsuit, and so there's no live case or controversy, right? There's just somebody who is suffering the consequences of that, and that to me is at the heart of why Chief Justice Roberts is in the dissent here, because the tone, what he is saying in his dissent, is very different from the three liberals. And my take on this is that Chief Justice realized that the Texas legislature designed a piece of trickery to get around the court. And so he just decided, you know what, I'm not going to go for that. And so let's just keep things as they are before we can unravel this clearly bogus piece of legal reasoning. And the majority just decided that no, they weren't going to, they were going to be ruled because as many of us on the left feel like they wanted to be ruled. They were eager to be ruled on this.
Really?
Yeah.
Huh.
On the right. Sorry.
My take on the ripeness piece of it, though, is all you need is if it's Planned Parenthood or whoever, somebody, and I don't want to encourage this, but look, this is what they do all the time, every day, perform an abortion and stake the 10 grand, right? That's
what you're saying.
Pocket change for a big national organization, or say, listen, we'll indemnify any doctor who performs an abortion under these circumstances, and then let somebody sue, and then you've got your case, and we're off to the races. And that's something that could take place in short order. And as I said, clearly, I think any federal district court would be compelled to follow what is the current precedent and grant that injunction. Or there's also state court remedies, which the court pointed out there too, that there could be ways to handle it in state court. And the other piece, and I'll admit that I haven't done any really reading or study on this, but the whole idea of deputizing citizens to essentially conduct a police type purpose.
Yeah.
I think there are issues there, and again, I haven't dug deep enough into it. There's a weird, in the law, when you have something that is a criminal law, and you say, well, here, if you violate this, there are criminal sanctions. In that case, courts do say, yes, it's ripe right away, because they don't expect someone to risk criminal penalty for violating the law. As opposed to this, which is risking civil penalty.
So then it sounds to me like what you're saying is how you see this playing out is that at some point in the very near future, some group will most likely perform an abortion in violation of this law and then be sued. And then in fairly short order, because of the highly questionable nature of this, some district judge will actually enjoin the law once there's actually that sort of live case.
Yes.
Okay. And that probably shouldn't take too long.
To me, that sort of goes also to the irreparable harm piece that hasn't been shown yet, because look, are there people who aren't performing abortions? Can one not be obtained because of this law? Well, there's some evidence to suggest that, but it's also tough to make that case that when you file at midnight, when the law goes into effect.
Right.
Right.
And that goes
if you file the lawsuit 2 weeks later or something like that, and say, listen, since this time, all these physicians have refused to provide abortions because they're afraid of the $10,000 penalty. I think your irreparable harm case is better.
Yeah, that makes sense. And I should point out that one unique part of the law, which I called it I called it a bogus argument. That idea that the law, some are saying the law can't be unconstitutional because this isn't a state action, but it's private action. But there's a long line of judicial precedents, including the court's own precedents, that courts are state actors, and so even though the state's not doing the enforcing directly, the mechanism of the courts is being enforced that way. And so you can't kind of get around the Constitution by saying, oh, no, the state's not involved because the state is.
It's like libel suits. Yeah. It's like New York Times Sullivan. One other thing I do want to mention, and I'll admit that, again, because we're doing the show early and I'm haven't totally prepared, and I'm not sure any degree of preparation would have made me ready for this. But the Texas law also includes an affirmative defense that the prohibition of the abortion would create an undue burden on the woman. And I'm sort of baffled as to how that works exactly.
Yeah, that is highly.
right? I mean, I mean, in practice, right?
I mean,
that's sort of the test that is applied for other abortion restrictions that Congress or states can place restrictions on abortion, suppose as long as there's no undue burden on the exercise of that right. But I'm not sure how that works as an affirmative defense.
Right. Yeah. Yeah. I think just generally speaking, the law was designed to sow chaos. And if you're the attorney for any one of these abortion providers, I think that the thing you would tell your client is, why don't you just hold off on abortions until we can kind of get this all, settled, basically. And so that's, it seems to be happening. And if you are an opponent of abortion, then any pause is a good thing and it's life saved and that sort of thing. And of course, if you are a proponent of reproductive rights, then any pause is a bad thing for, exactly opposite reasons. And, go ahead.
No, my take is, if I'm advising the abortion providers, and that's not something I'd probably do, but and again, my hesitancy in offering this advice, but from a legal perspective, is move forward. Let somebody sue you. Let's tee it up and let's go.
Very aggressive. Yeah. Okay. Well, I expect that will happen as well, and we'll be following that when it does. If we kind of get more broadly, public opinion has for a long time now, for decades really, favored not overturning Roe versus Wade, and there was all this talk about, will it be overturned? Well, I think we'll know a lot more in the court's upcoming term when they're hearing that Mississippi case that has a 15-week. After 15 weeks, abortions are banned. But for the last few decades, over half of Americans, around 58% in a recent survey, have been in favor of keeping Roe versus Wade. But majorities are also often in favor of various abortion restrictions, even ones that the court have ruled impose an undue burden. So a lot of the abortion positions really depends for a great deal of the public on sort of how questions are asked, how they're phrased in that sense.
Yeah. And there's a sense of I imagine if you ask most people, if the beginning of the question is, do you think blank should be overturned?
Yeah, no, don't overturn.
In most cases, you're going to get a no.
Yeah, exactly. And, in terms of the ramifications for this, at least in the short term, I mean, certainly Texas women who want to get an abortion at this point almost certainly will have to go out of state for it. And that could be potentially significant because I think the data is that something like 85 to 90% of women don't even necessarily know they're pregnant until after that 6-week period, which kind of makes sense. It's a very short period. But I think also the political ramifications, aside from, my feeling is that Texas women not able to exercise their constitutional right here until this is settled. But the political ramifications, other states, I think, are considering similar laws. In fact, I know they are. The president of Florida's state Senate said they're working on one right now. But I think that's a little maybe premature because I would expect a lot of states are just going to wait and see how this kind of plays out and maybe have something ready to go. But politically, I think this is certainly something that could energize Texas Democrats and maybe even national Democrats in the midterms, depending on how this plays out. What do you think, Jay?
Oh, yeah. And it's again, as I so often lament, can no one here play this game? I mean, it's sort of, you had sort of Biden and the Democrats really on the ropes the past couple weeks, months, and this is sort of giving them a gift. So, I'm speaking in the purely Machiavellian political sense of it.
Well, it just came up when it came up, but it was bad timing, you're saying.
Right. And I understand that, but that was passed back in May, and you couldn't have foreseen everything that would happen. But I think you could have. Republicans could have foreseen that. Look, this is going to look dumb and goofy, and for what? You know what I mean? I guess that's what troubles me.
Yeah.
Is what's the real benefit out of this? Because it strikes me as this is this is not going to be the case that overturns Roe versus Wade.
Yeah, no, it's just too
in
goofy
any
your words.
way, shape, or form. That this is not the constitutional. This is not setting up
I see what you're saying.
legitimate constitutional challenge.
And so basically, while there's maybe a short-term gain toward Texas politicians and to people who can prevent abortions in this sense, but the longer term, because of how it's structured and because it's pushing things, in your view, too far, it does maybe some longer term damage than a law more like the Mississippi one, which would potentially be a vehicle for the court to overturn Roe versus Wade.
Exactly. Yeah. I mean, if anything, you're making it harder.
Right.
It's for the court, right? I mean, to do what you're asking. Because you're making a law that is so extreme and so goofy and so riddled with these other weird issues like the private enforcement that and also I would very caution that the whole private enforcement bit scares the hell out of me.
Yeah.
For a whole lot of reasons.
Well, you're generally not a fan of just the state telling people to kind of have at it with the lawsuits. I mean, that's not your thing, generally speaking.
Well, I mean, I'm okay with the state actually saying people can have at it with lawsuits to some extent if those people are actually injured or something. For example, I know there've been other statutes like anti-abortion statutes that say, well, if you are the father of the aborted child, could you bring a wrongful death suit?
Yeah.
Against the abortion provider, or you're going to be the grandmother. So I mean, something like that, where again, there's a link there.
Right. Normally, people wouldn't have standing, but this legislation gives them standing, and that's the part you object to.
Exactly. Yeah. It sort of creates this nation of Karens, right?
Yeah.
That are just can just sort of. And there's very much fear of look, well, if my car doesn't have the right emission control or something like that, can anyone just sue me for violating environmental laws?
And from the state's perspective, that can be very convenient because it outsources surveillance and all that, which is the scary part of it.
And that's exactly what terrifies me, and why I think it's. That sets a bad precedent.
It's a deeply unconservative thing in that sense, you would say, or deeply unfreedom sort of thing, I guess you would say.
Yeah.
But yeah. All right. Well, let's take a quick break, and we will be back to talk about Texas, but in this case, it's a voting law. All right, Jay. So as you know, Texas recently passed, and Governor Abbott signed into law a pretty important voting law, at least I think people on both the left and the right would say. It's been talked about for a while. And of course, as many people know, Democrats in the Texas state legislature staged several walkouts to try to, at least they knew they couldn't stop it, but ideally to delay this legislation from going into effect. And eventually, though, it did. And I thought we would kind of start by talking about what this law is. Of course, as you would expect, many on the left are saying that it is, Jim Crowish and makes it a lot harder to vote. And certainly, when you look at states in terms of how difficult they are to vote in, Texas, in fact, is at the top of this list, actually, number 50 out of 50. So you might say, if you're a conservative, that means it's the most secure, I guess, certainly. But in any case, they made it even tougher. And so I thought what we do was kind of take a look at some of these provisions in this law and see, well, how good, how bad is this? How much concern?
How tough well, when you say made it tougher, I think we'll.
Yeah. So
we can start with sort of the baseline of how tough is it to vote, period. But go ahead.
Yeah, I see what you're saying. I'm sure we'll get into that because we generally do with these discussions. But, one of the highlight items is a ban on drive-through voting, which was particularly a big thing in Harris County, which is a Houston area. A lot of people there, a lot of Democrats. In fact, around 1 out of every 10 voters in Harris County use that option in 2020. And so that's one of the big things that it does. No more drive-through voting. And honestly, I don't really get why the state would step in and prevent drive-through voting. Jay, do you have any thoughts on how this makes elections more secure?
Yeah, because depends on who's in the car with you, right? typically when you vote, you are alone in your voting booth, or presumably you're alone filling out your absentee ballot. Um, there's to me a little bit of a problem of you go and you pick somebody up and you take them and say, hey, we're going to go vote. Does that person let's put it this way: you wouldn't allow someone to stand next to you in the actual voting booth while you fill out your ballot. Yet the idea is that you can have someone in your car while you do that. That troubles me a little bit, especially when you think about, well, look, you can have a drop box, mail drops. You could fill out your absentee ballot at home and drive through and drop it in the mailbox. That's fine, but this is a little different.
See, I guess that's what I don't understand, because this seems to me to be more secure, because in the drive-through locations, how it works, voters had to show a regular photo ID. They had to have their registration to vote verified, and so I mean, it seems to me that this is actually, you could argue, more secure in a sense, or more resistant to outside influence than, say, mail-in voting, absentee voting. There's no evidence of widespread issues with this, and so it seems to me if counties want to do this, it's not an election security issue. It's just making voting less convenient for no good reason. Because I understand your objections, which you've made many times, about nothing good happens at 3 a.m, drop boxes kind of thing. Okay, I could see where you'd say,
and it doesn't, yeah.
Well, we don't want to have this sort of box underneath next to this dumpster with who knows what could happen. I get that. I think that's reasonable. But just saying that, well, if a county wants to spend the resources, has the resources to basically allow the drive-through version of voting, to me that's just putting up an obstacle for no good reason.
Look, again, if you're asking me, is the drive-through voting a major threat to security? No, I don't think so. Is it less secure than actually voting in person? Yeah. As you point out, it may be even more secure than voting absentee. But I guess I still don't see it as this is somehow Jim Crow on steroids.
Sure, and
I don't. Saying, yeah. And again, keep in mind that most states, like say Delaware, don't offer drive-through voting, have never offered drive-through voting, and this was something that kind of was a creature of the pandemic. And you had sort of an exceptional year last year because of all these steps that had to be taken to allow people to vote, because you couldn't do in-person voting, and all of a sudden, if you don't adopt all of those, everything that was taken in last year, it's Jim Crow. And I think that's something I push back about. There's good reasons why we didn't have this before. And I, my security point is just one of them.
I mean,
go ahead. I'm so look,
I understand.
Say, does that make it marginally more difficult? I suppose. But
I understand. I mean, it makes it, and let me kind of try to contextualize this. It seems to me the argument that from the right, or at least a reasonable argument from the right, and I will put you in that camp, is that essentially 2020 was different. We all know that, and so removing special provisions that were put in place, or because we are under pandemic conditions, removing those is not rolling back voter rights, because those exemptions, exceptions, procedures that were designed were always going to be temporary. We were trading off a bit more access in a difficult time, and with the understanding, at least on the right, that it would make elections less secure, and that was okay to do given the extraordinary nature of what we were going through, but it's not okay to keep on doing that. Is that more or less?
Exactly.
Okay.
Couldn't have said it better myself. Yes.
And of course, the position on the left is we should have been doing this stuff anyway. And so the fact that we actually give people these make it easier for people to vote, pandemic or not, when we roll back that, pandemic or not, that's a move in the wrong direction. I'm sure you can understand that logic as well.
I guess I understand the logic, but I again disagree with the premise and the way that it's being stated. Right? I mean, you don't have the half your legislature depart for out of state to avoid voting on a law because you're trying to make the point that, well, this is slightly less voting will be slightly less convenient than it was last year.
Well, I mean,
right? That's not how this was built. This was built as this is Jim Crow. This is the worst thing since Selma. This and all this absolute nonsense.
Well, let me say, I want to break this in two parts because I think you're right that there's absolutely, when you look at what Jim Crow laws really were, this is not that. There's no question in my mind, but there's always that hyperbole. But I would argue that the fact that the Democrats walked out and tried to prevent this for as long as possible, I think that's totally warranted because on the left, I think generally speaking, we don't see this as making voting slightly more difficult. We see this as a move toward, less democracy and making it specifically more difficult for groups that have the hardest time voting, that are the most disadvantaged. And so that sets off a pretty big red flag on the left, and that's why you see this strong reaction. Why
does it again, someone once wrote into our Facebook page about is there a problem on the Democrat side, if they look at this honestly, of infantilizing some Democratic voters? That I mean, that's again, we get back to that. I mean, it's all the time, you always say, well, look, for me as a suburban, uber wealthy, uber educated white guy, voting's really easy. But I don't think I just don't think it's that hard, given all the various ways we can do it, even in Texas.
Yeah, right? And I think we can move on to other provisions, but as you I'm sure you'll point out that the Texas law actually expands voting access in a number of Republican
areas.
Counties. Yeah, funny how that works. Well, it most of the restrictions are going to affect largely Democratic areas, and the expansion will affect largely Republican areas. And I don't think that was exactly coincidental, certainly. But yeah, that provision you're talking about. Go ahead. I said it expands.
No, I'm talking about ideas, for example, of expanding in-person voting.
Yeah, I know exactly, and but that's based on county size, and so essentially the larger counties, the Democratic-leaning counties, were already doing this, and it's just an instruction, essentially, to the smaller Republican counties to say, hey, you have to hold voting open for longer. And so, to me, it was sort of a blatantly partisan thing on the part of the legislature, or at least
how's it partisan to say, look, Republican counties, you play by the same rules as the Democrat counties. No,
and that you're right. Let me retract and restate. I guess to say that it has a happily partisan advantage. How about that?
I mean, I suppose again, my sense is, and I think the numbers bear this out. Most Republicans still vote in person on election day,
more than Democrats.
As opposed to, that, But look, I just think, if you want to have statewide rules that apply statewide and they're uniform, and again, in this case, as you point out, the Democrat counties were already doing this. The expanded hours. I mean, one of the other pieces of the expanded hours were like, well, when can they expand it? Are the weekends and so forth? This voting law is much more generous than many states in terms. I think it's more generous than Ohio's, even than in terms of like weekend voting and so forth. It's not as generous as as far back as you can go, but I think in Ohio you still has to be weekdays, business hours.
Yeah. Well, let me run a provision by you that makes even less sense to me than the ban on drive-through voting, and that's the ban on 24-hour early voting, which was offered at a few locations in the state in 2020, Harris County being, I think, the epicenter of that. Now, so the law sets a window of 6 a.m. to 10 p.m. And on this, given the fact that, I understand, Jay, nothing good happens at 3 a.m., but
right.
if a county wants to use its resources to have personnel at a location, that literally then would be not a single difference between whether it's 9:30 or 9:30 p.m. or 1 a.m. So why tell a county that they can't do that? There can be no voter security issue involved there. It just would be a matter of administrative cost and convenience. And if counties want to do that, who's the state to say don't do that? Why would they do that?
Again, I'll go back to my nothing good happens at 3 a.m. Argument. But why? Right? I mean,
why not? I mean, why would the state step in with its boot on the foot of the county?
Is it your position that there's this great mass of Democratic voters out there who have been trying to get to the polls all the time, but they
No, you're missing my point.
They can't get there till 3 a.m.
It's my position that if local government, that it's my position of one of subsidiarity. That if local government can handle this problem, why would state step in to prevent this? There's no harm that is being done. I understand your argument, but it's not really an argument for doing this. In fact, it seems to me to be a deeply untraditional conservative argument, saying the state's just going to ban this because it feels like it, and with no good reason except for nothing good happens at 3 a.m. That's not a reason. That's a quip.
Well, but it's a good quip, though.
It is a good quip. I'll grant you that. Yeah.
If you're talking about staffing and who you're going to have there, and how efficient are these places in operating polling places, right? I mean, when you have issues of oh my gosh, there's problems at the polls, there's confusion at the polls, and keep in mind, most poll workers on election day are volunteers.
Yeah. No one wants the graveyard shift, right? The 3 a.m. shift, that would be rough. But that's my point is, if you really piss someone off, you're working from 3.
Perhaps questioning the quality of volunteer you get for the 3 a.m. shift.
Yeah, but that's
as well as the quality of employee you get for the 3 a.m. shift.
But even you understand that this is a weak argument.
Is there perhaps a motivation by some local governments to perhaps let things slide a little bit?
That's pretty weak.
After hours, right?
I know you're doing your best here, Jay, but you're floundering on this one. I guess you're trying to make, I understand, the best argument for your client here, the state of Texas, but you're on pretty rough ground with this one. I think let's move on.
No, I think this goes to just a general look. I'll ask people of just a general sense of who do you want choosing your representative? The people who voted at 7 a.m. or the people who voted at 3 or 4? In the sparsely, it just seems. I mean, look, it just strikes me as sketchy, and I'm not sure why Democrats are so insistent that they need this, right? When you've got something like, look, if you really want to vote at 3 or 4 in the morning, you can fill out your absentee ballot then and drop it off at the mailbox. It just strikes me as an invitation to mischief.
Well, voting after dark, that's an invitation to mischief. Why don't we make it and early in the morning, 6 a.m.? Why don't we say 9 to 5? That would be even better, right? Because we're in those hours of the day when only good, decent people can vote. I mean, that's how this sounds.
No. You would agree to, I think you would understand, and everyone would understand, there is a difference between 7 o'clock at night and 3 in the morning.
Well, for people who work a double shift or second shift, I mean, those are the sort of people that would benefit from this. And I don't think they're inherently sketchier or worse or anything than somebody who happens to be able to vote at noon. So
from you between 7 and 3, or
no, I'm saying that, yeah, I don't think that there's anything inherently sketchier about somebody who might, for various work or family reasons, end up having to, get off work at 5 a.m. and go and vote then. I don't think there's any reason to think that person is any sketchier or less entitled to access to the polls than you or I.
All right. It strikes me that this is, you're making the argument, obviously, on behalf of the Texas Democrats, that this is something that is desperately needed.
No, I'm not saying it's desperately needed. I don't think it would
it
make.
was so. I
No,
mean,
let
it was
me
so
be
needed
clear.
that-
Let me
that
be clear.
The Democrats are willing to decamp from Texas and go hide out in order to.
Well, it's
prevent it
not
from
one
taking
provision,
effect for a
Jay.
couple
It's
weeks.
the entirety of the legislation. They didn't walk out for one provision. It was the entirety of the
Right.
legislation. So I'm not saying that it's desperately needed. I think it'll have a very small marginal effect, but it's the point of making it more difficult for what I believe is no good reason and targeting a certain class of voters that I'm not okay with that. But
Okay.
anyway, why don't we move on?
You like the night owl voters.
There you go. Yeah,
Night owls for Baranowski.
yeah, absolutely. So it also makes it a felony for local election officials to send unsolicited applications to request a mail-in ballot or for them to use public funds to support groups that provide mail-in ballot applications. And again, this is one of these provisions that I don't see as being an election security issue, because if local officials have the funds and they want to send out unsolicited applications, that's not so people are free to say, I don't want to, I want to vote in person, but it gives them that option. It has nothing to do with the process. Again, it seems to me that this is much more a case of the state just wanting to make it more difficult and preventing local officials who are closer to people and should know more what their constituencies want. That should sound like a familiar conservative argument, that preventing them from doing that. And I think that's just wrong.
I would agree that one has me a little baffled.
Oh, okay.
Just because I know, for example, Ohio, I think, sends everybody. I mean, the Secretary of State literally sends everyone a application. And there's always sort of the game of what's called ballot chasing, right, where you check the registrations, then you send them the
right
request form and so forth. And of course, I don't have an issue with sending absentee ballot solicitation requests. I do have an issue with sending ballots.
Yeah, and I think that's reason. I can understand that issue certainly, but I'm glad that you at least find this provision a bit troubling. There's also
now again, do I find it troubling? I don't know if I find it troubling,
puzzling,
but yeah.
Well, I don't think it's,
to me. I don't necessarily see what's gained there. I do see what's gained in the drive-through or the 3 a.m. stuff. This one.
Well, you see you don't see what's gained here from maybe a public good sense, but you see what's gained from a partisan sense.
Not even that.
So you're saying, hold on one second. I mean, you're saying that there is this provision that these legislators talked about and decided to put in this bill that, as far as you can tell, has no purpose, that they put it in there for no reason you can figure out. Come on. Jay. I understand.
No. They obviously think there's a purpose. They obviously think that this will help.
Okay.
They're concerned that bigger Democratic counties will have these resources and that they will put these out and you will get more absentee ballots in. I just think it's the premise is sort of dubious that it makes a difference.
Okay. I just wanted to make sure that you understood what their premise was. All right.
Yeah, I understand what they're after. I just don't know that it works.
Okay. Now, there's also in this a new ID requirement for voting by mail. Applicants have to put in their driver's license number, or if they don't have one, the last 4 digits of their Social Security number on mail in their ballot applications. And this is one of these things that I thought, that seems reasonable to me. I'm not, as I talked about before, I'm not necessarily against reasonable ID requirements. I would prefer some sort of a free ID to people who can't afford the cost of a state-issued ID. I mean, it's not a huge expense necessarily. Texas charges, I checked, $16 for a state ID card, or $6 for people 60 and older. A driver's license costs $33. So not huge money, but I would like to see that. I would like to see that barrier a little bit lower for the poorest of the poor.
Yeah, fair enough. I mean, I think, look, Social Security number, your last 4 digits, that's free. That
to me seems like a reasonable sort of thing. There's another thing I actually liked about the law as well, is that a new process to allow voters to correct mail-in ballots that would otherwise be rejected for various technical errors. Apparently, voters will be able to make corrections online through some sort of a ballot tracking system that was previously approved by the legislature. And the same thing goes for technical errors in the actual ballot application. And there was actually some bipartisan agreement on this. I think Democrats really pushed for this and Republicans said, okay, essentially. And I think we would all agree that if people are just making technical errors and that can be fixed, then that should be fixed.
Yeah, absolutely.
So there you go.
But I would point out that having provisions like that makes it harder to square with the Jim Crow narrative.
Right. And again, you and I agree on that. This is not Jim Crow 2.0. It makes it harder to vote. And how big of a problem is that, and balancing that against alleged security issues? I mean, that's kind of where the left and the right differ on these things. So, yeah, I agree with you. This is not, Bull Connor in the 1950s or something like that. But I still don't think it's okay. Anyway. There are also these enhanced poll watcher protections. They're granted free movement within a polling place, but it also requires that poll watchers be trained and allows them to be removed from a polling place without warning if they violate the state penal code, which sounds like a good idea to me.
If you violate the state penal code, you ought to be removed anywhere.
There you go. And poll watchers also will have to swear an oath that they will not disrupt voting or harass voters. And, there has been a lot made about these poll watcher
harass. Come on, man.
Oh, yeah. I mean, this is the case where I think this is a reasonable measure to enhance the feeling of transparency and legitimacy. And so I'm okay with that. I know some on the left feel this is going to be like a poll watchers gone wild sort of thing. I don't think so. I think this is the sort of provision I would be able to support, certainly. So I think this is okay.
And again, I don't know what Texas law was like before this, but certainly most states have some sort of poll watcher system where you do go through some sort of registration process, and you go through some sort of training, and you're signed up and you're credentialed, and if you do something you're not supposed to do, they'll boot you. And I think those poll watchers, again, they're volunteer and they serve an important purpose in keeping everybody honest. And I think I'm all for that. So if this is just adding that credentialing process to Texas, I think that's great. Yeah,
I think so long as, like you said, there's that process and that they don't have being agents of intimidation, I'm okay with that too. There are also new rules for voter assistance in the law. Anyone who helps voters who need assistance filling out their ballot must swear an oath that they didn't pressure or coerce the voter into choosing them for assistance, and that their assistance was limited to reading the ballot to the voter, directing the voter to read the ballot, marking the voter's ballot, or directing the voter to mark the ballot. And I read that and I thought, well, that sounds okay with me. I don't have a problem with that at all, and I expect you don't either.
Nope.
So when I look at this in whole, and those are the main provisions.
It's like some stuff like that is things like I sort of like, wait, that wasn't in the law already?
Yeah.
That's
you would think it would be. So it seems to me that on the whole, this, as I said, Texas is the most, by political science analysis, various methodologies, Texas is the most difficult to vote in state. And this, to me, makes it marginally more difficult to vote in Texas. Though I will say that it makes it will be in 2022 less difficult to vote in Texas, I believe, than it was in 2018. Yeah, I think that's the case. But
that's progress.
Well, and it's not surprising when you look at the most difficult to vote in states: Texas, Georgia, Missouri, Mississippi, Tennessee, and then the 5 least difficult to vote in states: Oregon, Washington, Utah, maybe an outlier there, Illinois, and Maryland. That's kind of what you would expect. And we've talked about this a lot before, Jay, these various voting restrictions in states. And Texas is now the 18th state since the election that's tightened election rules. And again, I understand the argument, the logic on the right saying, well, there's public concern about legitimacy of elections, and so we're going to tighten up the laws. But of course, on the left, people are saying, well, who was stoking this public concern out of nothing when state officials say these elections were clean? Well, you were, and so this is clearly a way to suppress the vote. And I think there's absolutely truth to that.
Well, but I would say you're also some of this when we say tighten the rules. There is this sense of, well, we're rolling back the clock to 2019, right? A lot of these rules are essentially getting rid of pandemic specific procedures and procedures that were put in place because of the pandemic, and simply stopping those from becoming permanent, the new normal. Because I think there are issues there with trust, whether or not they manifested themselves in the actual results this time. I think there's still vulnerabilities, and those vulnerabilities you ought to take a look at.
So, we have a few minutes left. We kind of working on a hard deadline for this show. Jay, as I said, was willing to jump in, but he had to move around a lot on his schedule. But Jay, you and I have already talked about Afghanistan, and I don't think a whole lot has changed since our last conversation, except for the fact that, of course, the last U.S. troops left Afghanistan this past week, and President Biden addressed the country on this issue, kind of making the case, making the argument that this was an incredibly difficult maneuver. Anytime you try to plan an orderly withdrawal in the face of the enemy, that's one of the most difficult military things you can do. And it was a huge success in the sense of how many people were airlifted out in such a short period, certainly. And now there are apparently between 100 and 200 Americans, some of whom may want to stay because they have ties to the country, they have dual citizenship, but the president did vow that every one of those Americans who wants to get out, we will find a way to get you out. So I guess my question for you is, because not a lot has changed, I don't think, since our last conversation, are you feeling more or less confident about that sort of hostage situation thing we talked about a few weeks ago?
It depends how you mean. More confident that there is going to be a hostage situation. Yes.
Oh, really? So you think that the Taliban will, in fact, leverage the U.S.?
Well, I think they already have, right? I mean, if you have people of your own country who want to get out, but the idea is like, well, we'll negotiate to get them out. Well, then what you got is hostages, right?
Yeah, but do we know that that's happening right now?
If there's an American citizen living in France and decides, hey, I want to head back home, you don't have to negotiate with anyone for them to come back home.
Yeah, and I don't know that that's...
I would say even if there's an American citizen living in China or living in Iran, you don't have to negotiate with someone for them to come back home. If you got to negotiate for them to leave the country, you got a hostage situation.
And so you're saying that you think that this is happening at present, just not the sort of thing that's being publicly reported.
Well, it's a different type dynamic than, say everyone's holed up at the embassy, with blindfolds on.
Yeah.
But if you have a situation where people can't leave, then yes, they're essentially being held hostage. I mean, I point out. So, for example, the girls from California who went over to visit family.
Yeah.
It's something about a dozen or so. Again, they're U.S. citizens, and they are not able to leave. The other gentleman who's been literally held hostage, he was a contractor for some time. The Taliban still hasn't given him up. I mean, this tells you who they are. So there may be people of look, they're not handcuffed to a radiator or something,
right.
But they still can't leave.
Yeah, and certainly there are more than zero American. But there are. I think the President Biden's point was, at least my reading into it, is that was always going to be the case, just given the nature of any sort of withdrawal, and that is an issue separate from that. That is a function of withdrawing in general, no matter how we would have planned it. He mentioned that, as early as March, they had been reaching out to Americans in Afghanistan, letting them know. I think he said something like 19 times communications were sent out. And so this was going to happen. Let me finish. This was going to happen. Well, no, I'm not saying that, but I'm saying that this was going to happen with any sort of withdrawal, and there was no way to avoid some
right.
level.
Well, then in that case, the problem is when he makes statements saying look, I don't think the Taliban's certainly not going to take over. That's very unlikely that they would be running anything.
I see what you're saying.
And then also just a week ago, before this, saying we will not leave. Our troops will not leave until every American is out. That's blatantly. And look, if his position now is, well, this is always going to happen, and this is just the way things are, that was certainly untruthful at the time.
Well, and I think we both agreed that this was handled poorly, and I'm a bit skeptical about President Biden's defense as well. But on that note, we have reached that hard deadline of Jay's. And so, Jay, thank you very much. I appreciate it. And we will be back a little bit later on with the bonus show.
Absolutely. Talk to you later.
That's it for this episode, but Jay and I will be back very shortly with the full-length bonus episode in which we will be talking about, well, Joe Manchin calling for a strategic pause on spending, Social Security and Medicare insolvency, the House Armed Services Committee authorizing more money for defense than President Biden asked for, and Kevin McCarthy's warning or threat to firms complying with the January 6th Commission data request. All of that will be on the bonus show that should be here again, probably about 3 or 4 hours later than normal or after this show, just because Jay had to juggle around some stuff on his schedule. And if you'd like to get that, well, if you're a Patreon supporter, it will be in that feed. And if you're not a Patreon supporter, go to patreon.com/politicsguys to check it out and hopefully sign up. And again, if you'd like to get that bonus show, but you can't afford to support the show right now financially, totally not a problem. Email me, mike@politicsguys.com, and I will make that happen. One thing we'd really appreciate is if you could subscribe to the show, leave ratings and reviews on your podcast app of choice, and especially if you could share episodes on social media. If you got a question, comment, correction, just want to get in touch with us for any reason, our email address is mail@politicsguys.com. We're also on Facebook and Twitter, and you will find links for those in our show notes. A very special thanks, as always, to our excellent executive producers of the Politics Guys, Bruce Johnson, Wilma Moreno, Andra Masker, Daniel Toe, Chris Wilkerson, and Ryan Beasley. We'll be back with a new show next week. We hope you'll join us.